Your rights when a guardianship has been filed. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 626. Scale for State Court Administrative Office, PC for Probate Court. This form is readily obtainable. You're welcome to contact my office. We'd be happy to give it to you free of charge. With all of these scale forms, they are created by statutes and or court rules, and in this case, MCL 700.5306A is the statute that gives rise to this particular notice. Now, as the name suggests, it's a notice, which means that somebody's entitled to receive this information. Notice of rights to an alleged incapacitated individual. Alleged because at this particular juncture, when the notice is being provided, that individual has not yet been determined to be an incapacitated individual, which means a petition for guardianship has been filed. And as that person awaits the court hearing, this notice is provided by the guardian ad litem. The guardian ad litem appointed by the court to do a report and to meet with the individual. This notice is given to them to give them notice of their respective rights. And this particular mandate about this notice is set forth in the statute MCL, Michigan Compiled Laws, 700.5306A. It mandates that the guardian ad litem shall provide this notice to the person that is being sought guardianship over. Let's work our way through the form. And again, most of the form is simply a recitation of the statute to give the person who is being sought guardianship over information and notice of their respective rights. As you can see from the top left corner, it would identify the court and the file number. Let's talk about this particular area that is highlighted in the red rectangle. It's a notice that a petition has been filed. A petition has been filed in the courthouse. Remember, a guardianship is a court proceeding, which is different than a power of attorney, which is a estate planning document that you would sign while having your capacity. In this case, there's a petition filed in the court asking that a guardian be appointed to help you. Guardianship relates to care, well-being, to help you make decisions that you now make for yourself. If a guardian is appointed for you, the guardian will make decisions for you, such as medical care, placement, treatment, all of those things, and be responsible to get you those services. So again, they'd have access to that information and be able to make decisions on behalf of the individual. So this is giving notice to that person that when that petition has been filed, that person being sought to be the guardian will then have those legal authorities. The notice states all of your rights. Now again, here's where it gets complicated. These are your rights, but there are also statutes and court rules that apply to guardianship proceedings. So again, we strongly urge you, if you're working your way through a guardianship proceeding, to work with a skilled, competent probate lawyer who understands the statutes, the court rules, who understands the various forms, the language, the legalese. This is like a specialized language to understand how to navigate through this process. Now again, let's walk our way through it. Even the term guardian ad litem is quite confusing for people. Guardian ad litem is not the same as a guardian. A guardian ad litem may be appointed by the court to fully explain the rights and to give you notice of this information, then ultimately to write a report and recommendation to the court. Let's talk about these enumerated rights as set forth in the notice. A guardian ad litem must visit you in person. A guardian ad litem must explain the nature, purpose, and legal effects of an appointment of a guardian. A guardian ad litem must inform you that a guardian may have the power to execute a DNR, do not resuscitate, as well as other related issues for end of life. A guardian ad litem must explain your rights about the upcoming guardianship hearing. A guardian ad litem must inform you that you can object. So if the guardianship is being sought, you have a right to object, and you can object to the appointment of guardian, who the guardian is, the limitations of the guardian's power. All of these are embodied within your respective rights, and they're enumerated here. So remember, a guardian ad litem is the court-appointed person from the court to explain the rights to the person, as well as give notice and ultimately write a report and recommendation to the court. They're the eyes and ears. They're not the individual's attorney, which is quite different. A guardian ad litem is not the attorney for the individual. They are performing a very particular role. Again, some additional enumerated rights before at the hearing and at the court hearing on the petition for guardianship. You have the right to have the guardianship case started and conducted where you reside. So for example, if you are a Wayne County resident and the guardianship is filed in a different county, you have the right to the appropriate venue. So this is an important consideration here, and there's a lot that goes into that venue provision. You have the right to file a petition on your own behalf to have a guardian appointed for you. You have the right to be represented by an attorney. So for example, if you say, I object to the guardianship, I object to who is going to become my guardian, the court will appoint an attorney for you. If you can't afford an attorney, you can ask the court to appoint one, and it will be an expense of the county itself, public expense. You have the right to have a guardian ad litem appointed to represent you if you are not represented by an attorney. You have the right to an independent evaluation. So for example, if somebody brings forth a petition and says you need a guardian because of this doctor or this basis, you have the right to your own independent evaluation. And if you can't afford it, the government, the court, will pay for it. You have the right to be present at the hearing. You have the right to cross-examine witnesses. You have the right to present evidence. You have the right to cross-examine and hear all the evidence. You have the right to a trial by jury. You have a right to a trial by jury. A really important right. So in a guardianship matter, in the event of a dispute and objection, you actually have a right to a jury, and that it be closed to the public so you can maintain privacy. And you have the right to be personally visited by a guardian ad litem if one is appointed. Let's move our way onto the backside. Additional rights. You have a right to be informed of the name of each person that is being sought to be your guardian, and you have a right to be informed. And in fact, if the court is seeking a professional guardian, the court has to make a determination that all the family members or others within your circle, that they're not suitable to serve. So before they appoint a professional guardian, there has to be a determination of suitability. So you can actually nominate who you'd like to be the guardian of you. And you have the right to have your incapacity and the need for a guardian. It is the basis, the standard is clear and convincing evidence. So it's not just, this is a heightened standard. Clear and convincing evidence is a heightened standard. Rights when a guardian is appointed. So now after the guardianship is in place, so everything was before the guardianship was in place, now we're talking about the rights after the guardianship is in place. You have the right to object to the appointment of a successor guardian by will or other writing. You have the right to have the guardian's powers and the time period limited. So you can make requests for limitations. And you have the right to allow for maximum self-reliance and independence. We call this autonomy. The right to limit the powers of the guardian to the extent for you to have as much self-reliance and independence. So as you think about this, a guardian may perform all roles and a guardian may have a limitation, but the goal is to allow for self-reliance and independence, to allow the person that is having the guardianship over them to have as much independence and autonomy and self-reliance as possible. You have the right to periodic reviews. You have the right to an attorney appointed if issues are discovered during the review by the court. You have the right to demand at any time through an informal letter that that guardianship be modified or ended. So, for example, if there was a need for guardianship and that guardianship now should come to a close, you can write a letter or you can file a petition to do so, or if you're asking for a modification, you can do so. You have the right to a hearing within 28 days to review, modify, or terminate the guardianship. And again, here are the additional things about modifying, removal, consulting about major decisions in your life. And I'm not going to read through each one of these, but they're enumerated here to give you a sense that within the guardianship, you're not just forever removed from authority and decision making. You still have rights. So even though those guardianships are quite powerful over an individual, you still have rights. And you have the right to ask and demand and secure services to restore yourself to the best possible state of mental and physical well-being. so that you can return back without the guardianship. So the idea of guardianship, it's not really a construct for permanency, although it can be. It's really designed to restore you to the best possible state of mental and physical well-being. So sometimes a guardianship will continue all the way through the end of life, and sometimes a guardianship is there for a particular period of time. You have the right to have the guardian take reasonable care of clothing, furniture, vehicles, and personal effects. And of course, if there's a need to manage your own financial affairs outside of Social Security, you can ask for a conservatorship. There's so much that's going on here, but these are the rights that are enumerated under 700.5306A. This is the right that an individual will have when a guardianship is being sought. But there's so much content here that it's really important to consult with a skilled, competent, experienced probate attorney who understands this area and can guide you, whether you're the person seeking the guardianship or being sought guardianship over. Work with an attorney to make sure that they can guide you through this process and navigate you appropriately. At the Probate Pro, we are passionate about everything probate. If you have questions about a guardianship matter or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.